Hi, friends and clients of JLW Immigration Law Group. I am Jennifer Walker Gates, board certified immigration attorney, and I'm here today to talk about the new ICE memo indicating that they are opposing bond for almost everybody in immigration detention these days. We are going to be talking about how this no bond memo is playing out in real life with respect to people who get detained, um, potential strategies and tips for trying to get released in spite of this new development, and whatever other questions you have and want to bring to us. We are happy to help spread information and share information as best we can to help everyone be successful in your immigration case, whether you are going through deportation proceedings or you are applying for a benefit to USCIS. There's a lot of uncertainty and newness happening right now, a lot of things happening that have not happened before, that we haven't seen before, a lot of fear and a lot of anxiety. So I'm here to help share what we know about what's happening, so people can be as prepared as possible and have strategies in mind for your own particular case. Now, before I get into the substance of today's topic, I want to ask you to please like and subscribe. We've got the little banners popping up now. Give us a like and a follow on Facebook. Subscribe to our YouTube channel. We publish informational and educational content at least once a week on our channels. And we do that so that people can have a trustworthy resource for updated information. We don't necessarily come on here every time there's a change or an update. We wait to see what happens in real life, typically before actually commenting. There are so many rumors leaking out from the administration right now about things that are going to happen, plans, their intentions for handling immigration cases that seem really scary and frightening. Some of those actually come to pass and many of them do not. So we typically don't talk about things, rumors, on our channel. We talk about real world impact and how we can help people deal with what is actually happening. So please share our content, like it, leave us a comment, leave us a question. We do respond to those. Happy to do so anytime. And with that, let's get into it. So there is a new bond, let's say a new bond position, a new position that ICE has taken in immigration proceedings with individuals who are detained. And that is that if a person entered the United States at any time, even decades ago, if they entered without permission, they are not eligible for bond. Now, ICE does not get to make that determination all by themselves. There is a thing called the Immigration Nationality Act. That is the immigration law as written by Congress. And that law says that two categories of people are subject to what's called mandatory detention. One category involves people who have criminal convictions related to drugs, related to crimes involving moral turpitude or crimes of violence. Those are, people who might be a safety risk. Those people are subject to mandatory detention, okay, under the Immigration Nationality Act. Another category of people are people who have just been apprehended coming into the United States. The law does not say that everyone who's in the US without status should be subject to mandatory detention. There are some recent court decisions that kind of suggest that the courts may be moving towards an interpretation of the law like that. But if you just look at the plain text that is written by Congress, that is not what it says. So a lot of judges are not necessarily buying this argument from ICE that everybody who entered the US without permission is subject to mandatory detention. Many judges are saying, I don't see that. So they're still offering bonds and ordering people released on bond in immigration courts. However, ICE does have the authority to instruct detention officers not to allow people to pay bond. So there is right now a lot of tension happening between what judges are saying and what is happening on the ground. A lot of people are being granted bonds and then denied the opportunity to actually pay the bond for release purposes. ICE is also appealing judges' orders offering bonds when they have opposed them on under this new guidance. So the appellate courts are going to have to interpret the law clearly, and I'm sure there's going to be a whole flurry of lawsuits on this. It could even go up to the Supreme Court. Again, I would not be surprised if that happens. In the meantime, if someone is detained and then they are either told by the judge they can have a bond, but ICE doesn't let them pay it, or the judge says, I agree, you're not eligible for a bond, there are things that can be done. Number one is you can request release directly from ICE, okay? In the past, this has been a strategy that might have been viable sometimes. Right now, we are not seeing ICE releasing really anyone on like what they call parole from detention. We are just really not seeing that almost in any circumstances. So the other option is to go to the federal court and file what's called a petition for habeas corpus. Habeas corpus is this old, obviously a Latin phrase. It means to have the body, to produce the body, and it's a court proceeding that deals with unlawful detention. So when someone's detention violates the Constitution, violates their right to due process, violates the law in some way, it is possible to argue through a petition for habeas corpus that they should be released. And we are seeing that some federal courts are ordering release of individuals who are detained on this basis. That's really the way that a lot of us immigration attorneys are going to have to fight this now, because ICE has really started to lock down bonds and release on bonds for individuals who entered the United States without permission, even if they did so decades ago. We hope to have a swift resolution to this question, because the Trump administration is saying that they are interpreting the law as it was written. However, the law that they're referring to was published in the 1990s, and not until now is anyone saying that it means that people who entered without permission are not eligible for bond. It didn't change. So it can't really be that for decades we've been getting it wrong and now suddenly we're getting it right. That really shouldn't be the interpretation. So we will see what courts do with this. If we at JLW Immigration Law Group can help you with a detention matter, we are more than happy and honored to do so. We are licensed in federal courts around the United States, some in Texas, some in other places. We have handled a lot of federal litigation cases before the federal courts involving violations of the Immigration Nationality Act by government agencies like this. So we are ready, we stand ready and willing to help with unlawful detention matters as best we can. We are handling some of those in our office at this moment as we speak. And we hope to be able to report good results from those. I am seeing that we have some comments, and I'm glad that y'all are here, getting information, getting informed, educating yourselves. That's really brilliant, and that is how we're going to have to deal with these tough times is coming together, working together as communities and families collectively, etc. If you are a family who has someone, a loved one detained, you know that you are going to have to help that person's attorney. You're going to have to help that person get all the documents together. We as attorneys are going to be working with clients in detention more during this administration, fighting their cases against deportation while they're detained. That's clear. So we're going to be relying on whole communities of people to support our clients, not just the clients themselves. As a community, we will get through this one way or the other, probably a little battered by the end and stronger as well. So thank you all for being here. I'm going to go ahead and get to questions. Before I do, let me take another moment to ask you, subscribe, share, like our channel, leave comments. I'm happy to respond to them. Whether you are working with us, working on your own, working with another attorney, we want to make sure everyone has good, reliable information as they go through the immigration process. So again, we don't talk on our channel about rumors. We report on what is actually happening in the immigration world, in our experience with our colleagues, with our clients, so that people know what they actually should expect, not just what the rumors are saying. Okay, so let's see. We've got a question from Damien. The EAD is still not approved. So sorry, Damien. I know this has been an ongoing difficulty for you. I will say that sometimes we see people's residency get approved without their EAD ever being issued. It is unfortunate. It really depends on the office, where the residency was filed, where you're going to have your interview. Sometimes you go and you have your interview and you get approved, and you've never even gotten your EAD, or maybe you got your EAD a week before or something like that and haven't even had time to get the Social Security card yet, etc. That does happen. It's unfortunate because you don't get your money back for that EAD that you paid for, but it does happen sometimes. So submit your inquiry. If you are outside processing times and allowed to submit your inquiry to USCIS, definitely do that. You can also file a case with the USCIS or the DHS Ombudsman's office. Sometimes if a case is unduly delayed, they will help you. However, if your case has been pending for 5.5 months, they might still say it hasn't been long enough yet. So I hope that helps. I hope you get your EAD soon. Feel free to reach out directly if we can help you try to run that down any further. Okay, Jay says, I'm really worried about this no bond thing. Okay, I understand, Jay. Don't blame you. It is worrisome. There's a lot happening right now that we don't like and we wish wasn't happening. So all we can do is try to make sure that we are as informed and prepared as possible. If you might be subject to detention without being able to get bond, it is important to think about that. Unfortunately, plan for worst case scenarios, right? Think about what needs to be taken care of in advance in case that could happen. Really hope it doesn't happen to you or anyone you know or love. But the reality of the moment we are living in is we have to kind of think through these things before a crisis actually unfolds in our lives. So having an emergency fund, really important. Making sure like your children, your property, your banking, your rent, all of the things that obligations that you have as a person living out in the world, making sure you have a plan for someone to take care of those, or for those to be taken care of one way or another. And then thinking about the immigration law strategy is also, and knowing what that's going to be is really, really important. There are some people who get detained and don't get a bond, and they have a strong case for defending themselves against removal, even if it has to be done in detention. There are some people who don't really have that, and need to understand like the length of time they could be looking at detention versus do they want to accept a voluntary departure order if they're eligible for it versus will they likely just be deported versus would it make sense to file a habeas corpus petition in the federal court to try to get them out? There are a lot of factors to consider in each case, and it's important to have in mind what is likely to happen in your individual circumstances. So, we are doing a lot of this kind of emergency planning with clients these days. If we can help you in that way, we would be honored to do so. Please don't hesitate to reach out. Bart's, glad to be here again. I'm glad you're here. Got an EID expedited within 10 days of the application. Wow. Scheduled interview attended and no update since then. Interesting. Okay, I'm not sure what circumstances led to that expedite. That is exceedingly unusual in my experience, but I'm really glad that that happened for you. If you had your interview and no updates, that can happen. What I have seen happen in a number of cases is that, especially if there's anything in a case that might be a little unusual, after the interview, officers might have to continue performing background checks. They might have to, if they're a newish officer in their role, they might have to get approval from a supervisor before they're allowed to finalize and approve an application. There are a number of reasons that there can be a little delay after the interview and before the case is finalized. What can sometimes happen also in that window of time is that the file that belongs to that client could potentially get set on a shelf somewhere and kind of forgotten about. If there's any complicated work or additional work or anything like that that needs to happen, and the officer just doesn't want to deal with it right then, doesn't have time to deal with it right then, needs supervisory support to deal with it, whatever the case may be, sometimes a file can just kind of get stuck because the officer hasn't finished the work, doesn't want to, or hasn't had time. So it's really important to just kind of keep an eye on it. Pay attention to those 30-day marks. If, in my experience, USCIS asks for 120 days after an interview to be able to finalize a decision. If more than that time has elapsed and you still don't have a decision, then it becomes time to try to rattle some cages. You, as an applicant, can contact USCIS 1-800 number, the 1-800-375-5213. I'm not remembering the number right off the top of my head. I can dial it, but I'm not remembering how to say it. It's on their website, their National Customer Service Center. If you don't have an attorney, you can call them. And in my experience, it's really unlikely to help much, but it's important to do it anyway. Because if you don't get a response within 30 days of making that call, then an attorney might need to step in. And the attorney will want to be able to say, you know, the client has already called. Here's the confirmation number from that call. The client has already waited this amount of time. There wasn't any reason why the case shouldn't be approved. This work just needs to be complete. Somebody needs to find the file and complete the file. That is in my experience, you know, what typically works. There have been times when I have had to say, you know, if this isn't resolved within the next 30 days, we are going to file a lawsuit. And that, in my experience, always gets movement. In general, now with our local USCIS office in San Antonio, I have enough of a relationship with people who work there that I typically don't have to threaten litigation anymore in order for them to help resolve a client's case if it gets stuck in that way. So I hope that that helps. They want some time. It's really hard to be patient, especially these days with everything going on. But hopefully your case will be approved very soon. Next, Nancy, any news for DACA if ICE detains you? Oh, That is a great question. Um, in my experience with DACAs, the vast majority of them do not have this issue come up because they're extremely law abiding. However, if someone with DACA were to be detained by ICE, I think that the length of the detention would depend very much on the circumstances of the detention. Now, that's not going to be true 100% of the time. We still hear these outrageous cases of people who had DACA and were just pulled over for a speeding ticket or something and then ended up, dealing with really terrible officers and being detained. We've seen these stories in the news. I believe they are very much the exception. For the most part, people who have DACA have a driver's license. I believe that most of the time, people who are ending up in ICE detention, an enormous number of them are pulled over in ordinary traffic stops and they don't have a license. That is extremely common. It's something we hear about routinely. So if you have DACA, you're generally not driving without a license. You're generally not committing crimes at all, and you have very little or no reason to ever be detained by ICE. If a person who has DACA does commit a crime, DWI, any kind of theft, any kind of domestic violence, possession of illegal drugs, even in where it's legal, that's less of an issue, although it still is not legal. Marijuana is not legal at the federal level. So be really careful. If you're a non-citizen, if you live in a state where marijuana is legal, that is still a big risk for immigration purposes. Other than that, I think that, for the most part, DACAs are at very low risk of detention with immigration. And so hopefully that will continue, and that's what we have seen. And so I know that it's scary, but in my experience, in the vast majority of cases, if you have DACA, you're just working, you're renewing, hoping for a resolution, but not getting detained. That's typically what we're seeing right now. All right, a follow-up from Bart. Interview went well, and officer said everything looks good and not to worry. But it's almost a month now since the interview. Okay, yeah. So again, this is unfortunately something that is not uncommon. Officers, for whatever reason, just don't finalize the case. And so people end up waiting for their case to be approved when it is 100% approvable and should be approved already. So I'm glad. It sounds like everything's probably fine. It is most likely simply a matter of an officer needing to grab the file and finish it up and wrap it up and do the concluding steps. And for whatever reason, they haven't done that yet. But it's usually, in my experience, not because they're actually going to change their position and deny the case. If something comes up when somebody applies, in my experience with clients, if somebody applies for adjustment of status and they go for their interview and the interview goes well and the officer says everything looks good, and then something shifts, something comes up in the file, something comes up in the background check. This is really rare, first of all, because we always really vet and scrub our clients' background and eligibility to make sure we aren't going to be surprised by anything. But if something does come up, then the immigration officer will send a letter to the attorney and to the client saying, we need the following documentation. And generally, it will explain what it is that they want and what they're looking for. And they will give you either 30 or 90 days to respond. They'll give you a deadline, and you need to respond and turn in all the stuff by the deadline, and then the case will get approved. In my experience, I have never seen a case in my 20 years of practice where we went to an adjustment of status interview. The officer said, everything looks good. I think we're ready to go. It's just going to be a matter of, finalizing the background checks or whatever. And then we get a denial. I've never seen that happen. I have seen us get, a follow-up request for evidence. But even that is pretty unusual. And I have seen a number of cases take much longer than they should have just because the officer didn't finish the file. And that's the thing. It's so frustrating. But I have worked on a number of cases like that where I had to intervene just to go to USCIS, the field office, the supervisors, the attorneys, and say, please finish this work. Find the file and finish it. So hopefully that's what's going on for you. And if there is anything that we can do to support you in your case, please don't hesitate to reach out. Our contact information is scrolling along the bottom of the screen. Our phone number in Austin is 512-633-1785. Our website is jlw.law. You can call us or go online to schedule with me or any of the attorneys in our firm. We will be happy to assess your case and help you determine next steps. And yes, be comforted, hopefully. That is a big part of what we are here for right now, is empowering people with information that can really help tamp down the normal response that we always have to uncertainty, which is anxiety, right? So we help clarify the path forward as best we can so that we can all feel like our lives are a little bit more in our hands. How long before I should renew DACA if it expires on 4/26? That's a good question, Nancy. And people are, I think, having different responses to that right now. If you feel like you really just want to go ahead and file for renewal now, I don't think there's any prohibition now on doing that. Initially, when DACA first came out, they said don't ever file outside of this 120-day window before expiration. We've seen things kind of all over the map in that regard. People filing early and getting approved early, people filing early and getting approved a few months before expiration. If you do renew now and your card gets turned around quickly, which is what we have been seeing lately, is that DACA renewals turn around quickly within a few months. You may be giving up a few additional months of eligibility on the back end, or depending on what could happen with DACA any day now, right? We don't know what's going to happen with DACA or when. You could, secure your status for a little while longer. So it really is not, there's no rule book right now that says you should renew it 120 days before and no more than that. You can submit a renewal before then. You could submit a renewal right now. And the ultimate outcome is that you may be chopping off a few months of eligibility on the back end, if that you could have if you had waited. But on the other hand, by April of next year, we don't know. We don't know what the status is going to be. So I wish I had a better answer for you than that. But given the state of flux that we're in with DACA, that's the best I can do for you right now. And other than say, it might be a good idea if you don't know already, like kind of what you need in order to move towards a more permanent status, it would be good to kind of find out. We are still seeing DACA advanced parole get approved. We are still seeing people travel on DACA advanced parole and successfully without problems. This administration has not shut that down, gratefully. And